for responded evidence. On 1st of August, my application under 1310 was dismissed. Your Lordship, for the first application which was dismissed, again, I had to come to your Lordships, and your Lordships, let me directed the trial court for summoning of the particular orders. Those orders are very pertinent for the matter, for the conduct of the petitioner who has been accused of sexual assault and heinous allegations. Please, Your Lordship.
If I may mention, I filed a Section 37 petition. An order has been passed under Section 9 against me, where I was not even a party, neither to a party to the arbitration agreement. I'm only requesting for tomorrow, subject to office objections. I've already filed the petition.
May I also mention that I'm also a connected party in the very same impugned order. I'm so grateful.
Obliged, ma'am.
My Lordship, may I mention item number 4 in miscellaneous miscellaneous list? My Lordship, I have moved an adjournment slip, and I have even got an NOC.
No, not from the list. When the number is called, please make a mention. Yes, please.
Much obliged.
Kind attention. This is to inform to all concerned advocates and parties that the court proceeding of item number 37, case number writ petition civil 846023 with connected matter, FDC matter, is being live streamed. Objection, if any, may immediately conveyed to the Honorable Court. Item 37 to 107 and 34, FDC matter.
Lordship. Yes, please. Lordships were pleased to hear me in opening on the last occasion, Millets. And if your Lordships recall, the union was called to please produce the order. We just give a brief background again, if your Lordship will permit. Your Lordships will note, Millets, this is a matter where the Union of India has exercised its powers under Section 26A of the Drugs and Cosmetics Act to ban a series of formulations. Here we are dealing with something called FDCs, which are fixed dose combinations. Your Lordships recall, Millets, that this is a matter where previously the matter came up before your Lordships. The matter traveled all the way up to the Honorable Supreme Court. The Honorable Supreme Court, Millets, then took a view, gave the government the ability to segregate pre-88 FDCs, and left it open to them to take a view on whether they wanted to examine them. Pursuant thereto, a committee was constituted. That committee ultimately has made some recommendations. Those recommendations have ultimately been acted upon, resulting in the impugned order. It is our case, as petitioners, that the mandate of what the Honorable Supreme Court directed has not been complied with. And in any event, the statutory mandate is not to ban. The statutory mandate is to have a graded response, with the ban being the ultimate response in an appropriate case where the public interest is so overwhelmingly large that the product need not be there. The Lordships will permit me to start with the impugned order in the first place, and then work backwards from there. Please straight away have the impugned notification. Your Lordships will find that at page 40, and the English version at the bottom of that page.
Which file number?
I would be referring to item number. That it will be. This will be item 41. On a lighter note, since it is title is elaborate, if your Lordships will permit me to elaborate. No. Please elaborate. Lordship sees the documents, your Lordship, Justice Narula has them.
Yes.
Whereas the central government, in exercise of the powers conferred by Section 26A of the Drugs and Cosmetics Act, prohibited the manufacture for sale and distribution for human use of drug fixed dose combination of flupheniramine maleate plus codeine syrup. Your Lordship will find codeine and codeine phosphate used interchangeably. Within notification number 909, published in the Gazette of India, dated so and so. Whereas in light of directions given by the Honorable Supreme Court in its judgment dated 15th of December 2017 in the case of the Union of India versus Pfizer, in appeal number so and so, mentioning that in respect of 15 FDCs,
Just mute. Yes.
mentioning that in the case of in respect of 15 FDCs claimed to be approved prior to 1988, the central government, and please note, may, if it so chooses, de novo carry out an inquiry as to whether fixed dose combinations licensed prior to 1988 should be the subject matter of a notification under Section 26A of the Drugs and Cosmetics Act 1940. Matter was examined by an expert committee constituted by the Government of India, which furnished its report on the 1st of April 2022. And I make no comment because of that date on the quality of that report. In respect of the above, drug to the central government and the Drug Technical Advisory Committee Board constituted under Section 5 of the Drugs and Cosmetics Act agreed to the report submitted by the expert committee. And whereas the expert committee recommended that there is no, please note, therapeutic justification for the ingredients contained in this FDC. Lordship said note that the individual components are not banned. So therefore, the first point would be
FDC is A plus
yes,
A plus B.
fixed dose combination, say fixed dose of A and
A
B.
is not banned, B is
Not banned, but the combination they say has been banned, and the logic is that there is no therapeutic justification for the ingredients contained in the FDC. But that's not all, because that would have made my life very easy. The caveat is, and the FDC, please again note, may involve a risk to human beings.
Yeah.
Hence, in the larger public interest, it is necessary to prohibit the manufacture, sale, or distribution of this FDC under Section 26A of the Drugs and Cosmetics Act. In view of the above, any kind of regulation or restriction to allow for use in patients, please note, is not justifiable. I would have thought the logic should have been the other way around. But this is the document that my friend has to defend, and I have to challenge. Therefore, only prohibition under 26A is recommended. And whereas on the basis of the recommendations of the expert committee and the DTAB, the central government is satisfied that it is necessary and expedient in public interest to regulate by way of prohibition the manufacture for sale and distribution for human use of the said drug in the country. Now, therefore, in supersession of the notification, the previous one, the central government, last two sentences, the last two lines rather, central government hereby prohibits the manufacture for sale or distribution for human use of drug fixed dose combination of chlorpheniramine maleate plus codeine syrup with immediate effect. I'll pause here. Your Lordship sees.
So the first question, are you pre-1988?
I am pre-88.
What was the license that you had?
Well, I was given a license. Well, the regime of pre-98 was slightly different, if your Lordship's note. And that's why, if your Lordship will have the Drugs and Cosmetics Act, if I could just take your Lordships briefly through that framework.
Yeah.
Please straight away have Section 26A of the Drugs and Cosmetics Act.
Yes, please.
Your Lordship will note, 26A was inserted by Act 68 of 1982 in the first instance.
First of February 1980.
Yes.
Your FDC is prior to this or after
FDC.
this? Prior to this.
Yes, and in fact, I have a CDSO approval in 1995. So therefore, my point is,
Since when you are manufacturing? Producing it.
This petitioner has been in existence since 2007. This medicine has been in existence since much earlier.
Carbon nine.
Yeah,
Or manufacturing.
So I have been in existence since 2007. The medicine, of course, this combination has been in the market prior to that. That's why I said the combination itself gets CDSO approval as far back as 1995. And that's as of 10th of March 95. Your Lordship will find that in my additional documents, if your Lordships will have.
If not. Right.
So you're not in this follow. You are pre-1988, you claim.
Yes. Well, the product is pre-1988. It's the FDC, not the individual. I'm so sorry.
Let's see that pre-1988
Yes.
FDC approval.
Yes.
What approval was in place for this FDC pre-1988?
Well, I'm sorry. The erstwhile regime did not require a central government approval. That's the point. And that's why I said, if I could just.
What was the approval for this?
Look, the statute, if your Lordship notes, imports were governed by the central government and are regulated by the central government.
So for this drug in question, this FDC in question.
Yes.
What was the approvals in place?
Well, it's state licensing authority.
Which is that?
Yes. That perhaps is not on record. It's not a disputed position. It's my specific approval is not on record, but that is not a disputed position that this combination has been licensed by state authorities. In fact, this entire dispute arises.
What basis was this license granted for this particular combination?
Well, I'm grateful for it. May I then give your lordships a brief backup? What your lordship is putting to me is the framework which leads to this.
So because your substantial argument is on the fact that you have been in existence for a substantial period of
Yes,
time. So that substantial period of time is not yours. That is of the FDC in question.
Yes,
So the FDC in question, what was the license in place?
yes.
What was the material on the basis of which such license was granted?
Well, with respect,
Which can show us to the court
I will
that
press.
this drug was efficacious, it had the therapeutic.
I'll step back.
efficacy.
I'll step back. Well, it is a product that is ultimately approved for sale in the market.
No, we get the
Number one.
understand that. We would like to see that. What is the approval in place?
Yes, number one. Number two is, the fact that the product has been approved is not in dispute. That's why I say perhaps that's not.
Right now, we are not on that whether the product was approved or not. We are only questioning the efficacy.
No, I'm sorry, Minister.
So you will have to demonstrate what was in place.
I'm stepping back.
Demonstrate.
Your lordship is right, and that's why I said, may I give your lordships two versions, and that's why I said, your lordship will just permit me. The dispute here arises because, the parliamentary committee takes a view, and my friend has very fairly, placed that entire material on record to say that there was rampant licensing that was the allegation by state authorities. And an evaluation of various products in the market, was done, where the committee found that perhaps, some corners were cut. That's the premise on which this entire exercise starts. The regulatory regime that existed prior was where, for imports, the center specifically looked at it. State licensing authorities dealt with this. And of course, for products to be sold in any event in India today, there is the Central Drug Standard Organization, the CDSO, which has to grant approval. Please just note one document as far as I'm concerned, so that I can cut the controversy short. This combination is a CDSO combination as far back as 1995. And this is carved out as a pre-88 product even by the central government. So therefore, on that there is no dispute.
No,
and address your lordships. I'm sorry.
Whether dispute or not, please show it to us. Demonstrate that pre-1988, this was a pleasing question.
Yes,
for which there was approval in place.
Well, that the notification itself, otherwise the notification would not make any sense.
See, Mr. Rao, what was the basis for granting the approval is today in question.
And that basis with respect, is not on the record, let the state licensing authorities or the central government, because the central government is the one that questions that. So either the central government says that the basis is misconceived. Yes.
Hey, you are disclaiming the observations made by the committee.
Well, I'll come to that.
So on what basis?
Yes,
Your basis, again, I'm saying, you're saying that this drug has been in existence.
Yes.
You cannot straight away impose a ban for the sale of such a drug.
Yes.
So what was in your hand when you had this license? What was the material on the basis of which you could demonstrate the efficacy of this drug?
I'm so sorry. May I just show your lordships straight away? Then what I can show your lordships with reference to the record is only this. Please permit me, sir. I know. That's it. May I just show your lordships? It's two parts. If your lordships will straight away have, the order constituting the expert committee. Because to answer your lordship's question, what is the material I had to show that my drug was efficacious? That material is not on record. I must be very careful.
You don't have.
I must be very careful. But may I tell your lordships why that is not really an issue?
Material then you presented to claim that this.
That I produced before the committee here, which has not been considered. That's a separate issue. That's why. But your lordship's question to me was, when I launched the product, what was the material?
When a study was carried out at that point.
Well, I asked that specific question. Please also.
The trial was carried out.
Well, drug trials are in fact not necessary in all products in the first instance. That's the other
When a
point.
study was carried out. Product was
Not-
drug licensing.
At that time, there was no requirement. I don't believe we did it. I've asked that question. Well, there is no material that at least I have on the record to demonstrate that I did some studies, and those studies are readily available to demonstrate efficacy. I must be very candid. I must be fair to the court. That's one. No, that's okay. That's one thing I'm coming to. The question is when the product was approved. Absolutely. So may I just make two distinctions? One is when the product was first approved or first was launched in India. And that's why I said, your lordships will distinguish product, combination, and entity as three different buckets. The product comes into India, somebody launches it. Then that has happened as a matter of historical fact. That product has been in the market as a matter of historical fact, no dispute on that. Like this, there are several other combinations, including individual products and combinations that have been in the market. Which is why the central government at some point in time decides to take stock and says there are a bunch of things in the market, some of which perhaps are of questionable efficacy, some of these perhaps have been approved without following processes. Now, the process that was applicable pre-88 is also different. And that's the point I wanted to make, but
I'm sorry to, I will not interrupt, sir. Just a point. Even pre-88, safety and efficacy had to be certified by the center.
That is what we wanted to
Yes.
see. That is what
I will show that. Our position.
I'll show it right now. But I've placed
It
on that.
can't be, we demand that it can't be unregulated regime.
No, it's not unregulated. The difference is only this. That's why I said, it's imported.
Lord, I'll just take a minute here and, so, my lord, basically, if your lordship will look at the Supreme Court judgment, in paragraph 5, there is an observation. If your lordship will take page 170 of my friend's paper book.
Annexure.
My lord, this is annexure, annexure P6.
P6, the Supreme Court's judgment.
Yes, please. Which paragraph?
Lord, I was referring to paragraph 5.
Yes, please.
My lord, now exactly why this pre-88 issue has arisen. Now, my lord, this is a reference to the Kokati Committee. I won't trouble your lordship with that entire history right now. But what happens is, the Kokati Committee has observed this, which is what the Supreme Court has noticed. The first assessment report of the aforesaid committee was submitted by the ministry on so-and-so and was presented before the ministry on so-and-so, wherein the committee was requested to mention detailed reasons given against each FTC considered as irrational by the committee. The committee did not discuss FTCs already approved by the DCGI and FTCs which were licensed pre-88, that is before the introduction of Schedule Y to the Drugs Act. The committee stated that in case the committee made any comment with respect to the above inadvertently, it shall be treated and not discussed. That's the reason why, my lord, the Supreme Court said that since this was not an issue, you could not have banned pre-88 drugs. Therefore, my lord, the Supreme Court said you must consider this afresh. You are at liberty to do so. Now, what the Supreme Court proceeds on the assumption is that there are some products that were licensed prior to 1988. Why this is relevant, my lord, is this. There is a certain date, my lord, your lordship will just note that. 21st of September, 1988. What happened, my lord, was 21st of September, 1988 is a regime that came into place with regard to approvals. So, my lord, broadly, this is the categorization. Safety and efficacy is always certified by us at the center. The actual manufacture of the product takes place through state licensing authorities. So, my lord, for example, somebody comes to me in the center, I give them permission to conduct their trials, I evaluate them. So, there is a bit of a digression here, my lord. Sometimes the product is already in the market abroad. So, that data is also used by the applicant to tell us that, look, this product is already there. But, my lord, again, the question is, how does that drug react to this population? So, you may not conduct a full-fledged trial because it's not a new drug in that sense. But because it is a new drug in India, you will still conduct a trial, but may not be phase 1, phase 2, phase 3. You may only conduct a truncated procedure. Yes. Now, the actual manufacturer is certified, is licensed on the basis of a license given by the state licensing authority because will not be separate. What are the logistic requirements that you have satisfied? Do you have the technical personnel? Do you have the scientific personnel for the actual manufacture of the drug? So there are two different aspects. This position existed even prior to 1988. Even post 1988, this same position continued, but it became more developed. Now, in 2019, my lord, you have the new drug clinical trial rules, which again provide for the same position, but like every regulatory regime, it has evolved from time to time. So, my lord, yes, there was some confusion at some point of time about something or the other, but the rules were very clear that even prior to 1988, you were required to prove safety and efficacy because if my friends, if there is no proof of safety and efficacy, my lord, the drug is, my lord,
So for this combination,
yeah,
there is no safety or efficacy.
prior to 88, there is none. It is only in 1995. So, my lord, in that sense, in the Supreme Court, I don't think that
This
position
is why
was
the
correct.
committee granted them opportunity to produce the material.
That's right. That is, your lordship's absolutely right. In fact, my lord, perhaps in the Supreme Court, maybe we should have clarified that position. Maybe they could have clarified the position. Actually speaking, when the Supreme Court says pre-88, we are not talking about products in the market already. Now, the product may be in the market which may not be approved, but the fact that you are in the market doesn't give you any legitimacy. Question is whether pre-88 you were approved or not. Because if you were approved, then there is a separate question because Kokati committee says very clearly that we are not going into them. So fair enough. If you have not looked at them, then you can't be taken by surprise. You must do a fresh exercise, which is what you have done.
So, pre-1988, for the efficacy and safety approval, what provision was governing the?
Your lordship will take the rules. I placed the rules on record in my compilation in volume 4. Lordship has that? Volume 4, Mullah.
मेरे इसमें बोल रहे हैं Volume 4 in item number 41.
In item 40, Lordship. I filed a set of documents, Mullah.
Index dated 9th October.
Yes, Mullah.
I think
Yes, you're right.
I have a
Mullah, we've got clear copies, Mullah. I think I meant it right. Not clear.
I've given it.
As per.
That's only one. Only the leading item.
Mullah, has that?
This one, please, once.
Well, I've handed over a clearer copy.
Yes, please.
Mullah, if your lordship will take, first and foremost, Mullah, the definition of a new drug, which your lordship will find in Rule 30, Mullah, A explanation. So, Mullah, historically, what's been happening is, at one point of time, like in any industry, Mullah, manufacture was really not taking place in India. A lot was being imported. So the focus at that point of time was actually more on the question of regulation of import. Section 26A came in 1982 because, Mullah, in term, I'm sorry,
26A came into 83.
In 1982, because, Mullah, we were having a situation where there was a lot of drugs in the market which were not really, Mullah, serving the purpose. But if your lordship will take this explanation on 30A, for the purposes of this rule, may I read, Mullah?
Yes, please.
For the purposes of this rule, new drug means a drug the composition of which is such that the drug is not generally recognized among experts as safe for use under conditions recommended or suggested in the label thereof, and includes any drug the composition of which is such that the drug as a result of investigations for determining its safety or for use under such conditions is so recognized, but which has not otherwise done during the course of such investigation been used to a large extent or for any appreciable length of time under the said condition. So, Mullah, by and large, the meaning being that there is a drug that has not been tested for safety and efficacy. Now, Mullah, if your lordship will take 69B.
So, but Rule 30 is dealing with the prohibition of.
That's it. Yes, that's dealing with import. But what your lordship are concerned with, 69B. Your lordship are 69B?
Yes.
Yes.
The reason why I referred to 30A, Lord, was because the
Explanation.
that's right. The explanation in 69B says new drug here means the new drug in 30A. Application to manufacture new drugs other than drugs classifiable under Schedule C1 and C and C1. Subject to other provisions of these rules, no new drug shall be manufactured unless it is previously approved by the licensing authority under Rule 21. Now, Rule 21, my lord, is the licensing authority, that is the central government. So safety and efficacy was otherwise still required to be satisfied. And that, my lord, your lordship will again find in Roman 2 again, the manufacturer of a new drug, when applying for approval to the licensing authority,
Sorry, Mr. Gitman, where are you now?
I am reading rule 69. Well, I read 1 and now I'm reading 2.
2.
The manufacturer of a new drug, when applying for approval to the licensing authority mentioned in rule 1, shall produce all documentary and other evidence relating to its standards of quality, purity, strength, and such other information as may be required, including the results of therapeutic trials carried out with it.
So you mean to say this is missing in their case?
Well, if it is pre-88, this is the rule that applies. And, well, irrespective of who's manufacturing it, they should be having this. But what my friend says, not my friend says, and he's right about that, that this was actually approved only in 95. So therefore, well, whether it's being manufactured prior to 88 or not manufactured prior to 88 doesn't mean that it is safe. But if safety and efficacy has been approved only in 95, then, my lord, it is actually speaking not a pre-88 license term.
So in 95, they have a license now.
They have an absolute, yes.
Licenses we've had, but I can't sell without a license.
Just explain that. Let me explain that. Well, when my friend refers, license begins to be used interchangeably. There is a manufacturing license under Rule 24,
Right.
which is given by the state. There is a approval which is given under Form 44 Schedule Y, which your lordships have noticed in paragraph 5 for my lord Justice Narayan. So that is what they got, which is the Schedule Y approval in 1995 one. When I say they, my lord, I don't mean the petitioner or I don't think any of them. There's some other company, I think it was Roche, that got the approval in 1995. So that's the approval that, my lord, ultimately is the approval that I think they're going to ultimately have to rely on. Because pre-88 there's no approval.
So this approval has been granted by the central government.
By us, yes, by the CDS.
And what was the material presented at that point of time for
But
granting?
in 1995, I think the company would have applied, and on that basis, that approval would have been granted.
Without any scientific
Without any-
basis,
It cannot be, Manoj.
without any study.
It would have been, Malad, I'm not sure. We have a excellent record. It's an old record. We are finding that. But your lordship, perhaps, Malad, if I was to be frank about this, yes, at that point of time, there was a lot, Malad, that we had to do. We were still a work in progress. And therefore, Malad, we may have, Malad, not gone about it in the best of ways possible. We are obviously entitled to, Malad, revise our position. We are obviously entitled to make sure that the best drugs are in the market. After all, Malad, that's the nature of this industry. You have to keep improving, keep upgrading. We have to keep getting, Malad, making sure that medication that works and is otherwise, Malad, not susceptible to abuse or is otherwise not dangerous, is taken out of the market.
So currently, they do not have, and you also do not have any record as to what was presented in 1990.
In 1995,
They will have a record.
people have a record right now. That is
You
something
also
that we
do
know.
not have the record.
Manoj, in fact, I was not the one who applied, but like I said, Manoj, the product, Manoj, please just note 3 things.
No, but do we have the record?
But that-
For this particular.
Because I don't have the record, that's why I said my record is not here. But please note, once the combination has been approved as far
I
as
understand, but what was the material?
because that only the authority which granted that approval will have.
Who applied for this approval?
Because that's
That also is not true.
that's not.
No, I'll just correct that.
Because the combination that order is on record, Manoj, it's in my additional documents. If your lordships will have that. And it's a bulk list which comes out from time to time. Annexure P16, page 84 of my additional documents filed.
Okay, showing what? That
Because
is
which shows, amongst other things, that I figure at serial number 1217 for a combination, Manoj, of a 5 ml for dry cough, chlorpheniramine maleate 4 mg, codeine phosphate 10 mg, N395 is the date of approval by CDS.
No, but what was the material we do not know?
Like I said, that's why I started. I must be fair. I asked for that exact question. I don't have the material that he. Yes.
Therefore, first hurdle and first question to be answered is, are you pre-1988 or post-1988?
According to me, I'm pre-98 because I've been treated as that, and I'll show you lordships why.
Because your approval,
Yes.
which you're relying upon, is coming up in 1995.
Well, that approval with respect, and that's why I said, well, your lordships will only note. If I was not pre-98, I shouldn't even be part of this notification. Then.
That's right.
That is what they're saying.
That's what.
No, I'm so sorry. My friend has banned me under this notification saying I'm part of the 15 FDCs.
Because now it is because of the Supreme Court direction that
That's
has
right.
been done.
I'm so sorry, Manoj. Would your lordships just permit me?
They're saying that there is no clarity on this aspect.
I'm sorry, Manoj.
See, pre-1988, you don't have anything. 1995, again, there
I'm
is.
sorry, Manoj.
There's no material.
Would your lordship only permit me to just make three things clear?
And that is why the Supreme Court said constitute a committee.
No difficulty.
You will be given a
The
chance.
Supreme
to
Court says
represent
constitute
the
a
case.
committee and look at pre-88 separately. I am treated as pre-88 for the purposes of this exercise. That's the point I want to make. So today,
You're right, you have been treated.
yes, please.
But what is the basis for treating you?
Well, it's two parts. Well, it's clearly the product, the
Because you
FDC.
surfaced in that list in 1995.
No, I'm so sorry. That's why I said, Manoj, your lordship, will just please consider three things. My friend, your lordship asked me a very pointed question. What is the material when the product was introduced? Manoj, I cannot give your lordships that. I must be fair. It's not available.
When was it introduced?
Because that also, the exact date is not there, but it is pre-88. Please take that because then I'll show your lordships, not me. Well, I'll show you the Union of India takes that position. Today, my friend, of course, is singing a slightly different tune, and I'm a little surprised to hear that. But your lordships will see the record as it speaks. This is not virgin territory. This has traveled up all the way up to the Supreme Court. And that's why I said, if my friend is right that I am not pre-98, pre-88, then Manoj, I don't know why I'm in that notification. Because this notification is for the 15 FDCs, which were before the Supreme Court deemed to be pre-21/9/1988.
That is because my friends went to Supreme Court and said they are pre-88.
My friend doesn't challenge it. He was
Of
there.
course, I'm not challenging you. What's the challenge it? We went by your statement, and ultimately we have to examine it. We examine it. I show you the orders. Affidavit 9.
Yes.
Yes,
Would your lordship just permit me, Manoj, just to cut the controversy, please have P6, which is the judgment of the Honorable Supreme Court, page 163 of my paper. And like I said, Manoj, I am not here to even tell your lordships that I don't need to be put under a scanner. Please don't take that, Manoj, as a submission number one. Number two, please take it. It is nobody's case that I am selling illegal or I was selling illegally without a license. So there are three parts. One is, Manoj, a product being approved for sale or has been introduced in the Indian market. Manoj, your lordship knows at times how these things work. Something comes into the market, the regulator spots. Technically speaking, my friend is absolutely right. Nothing should come into the market without some sort of approval from some authority.
That's right.
It has to be a competent authority. The lordship also, my friend, fairly states, and this is a curious statute, Manoj, where the statute is only 33 sections. So one understands that the nature of the beast is such that it will ultimately have to be dealt with, Manoj, by rules and delegated legislation because it will need, Manoj, tailoring to meet circumstances on the ground from time to time. Having said that, the regulatory framework that the statute contemplates is really this broad distinction. Imports are exclusively regulated by the center. The state licensing authorities were the ones that were tasked with the responsibility of giving licenses for manufacture, production, etc., etc. Now, Manoj, I could start in the first instance by saying the fact that the central licensing authority, the CDSO, that's the standards authority, has certified this product and has approved it as far back as 95. I'll pause there for a minute. Should be enough to say that this product is kosher in the first instance. But my friend is also right. We discover the effects of products over time. I asked myself, Manoj, just like thalidomide, which was, Manoj, the world's answer to something, and then of course we discovered the crippling and devastating effects of that years down the line, and people are still suffering the consequences. Now, is this one of those products where consumption over a period of time has resulted in such gross consequences as to warrant the last nail in the coffin, as it were, as the statute suggests, of prohibition? That's the, well, so the question before your lordships is, I have been banned. Is the ban justified as a matter of law and as a matter of fact? That's the broad legal question. But of course, yes, I must satisfy your lordships that A, the product otherwise has gone through the hoops, as it were. Number two, that the product has been tested and each of us satisfies whatever regulatory requirements are met.
Again, I'll have to stop you there.
Yes.
How? 388, you're not able to demonstrate.
No, no, no.
95, again, no material before the court as to how the efficacy has been tested for this product.
Well,
Only the length of time and the consumption of drug is all that you will have.
Let me step back. Your Lordship will just give me 1 minute. There is some material before the Supreme Court which is not part of my paper book, which is where the petitioners put a list to say what was available in the market pre and post. But I see the point Your Lordship is making.
388, nothing is being shown to us.
So Your Lordship is right. And then, please.
95, your name does surface in the list, but again, the government doesn't have the record for this particular drug in question. No
You
record
don't have
for
the record.
Your Lordship, that's why I said I in any event can't have the record. I'm on 2007.
It has been tested, time tested is only the length of time you are
So it's
demonstrating.
two parts. And that's why I said, Your Lordship, please just permit me to make 2 points. The petitioner before Your Lordships in 41 cannot even say anything pre-2007. It did not exist. The petitioner steps into a domain where, Manoj, it's like saying you're manufacturing candy.
Correct.
Somebody else has been manufacturing candy. I've stepped into the market. The question is candy permitted to be manufactured? The fact of the matter is, Manoj, please note what the Supreme Court says. And that's why I said my friend's position and my position. I don't want to put words today. We can't reopen words that have been settled by the Supreme Court. And then, of course, I want to link it to my friend's conduct subsequently. Please straight away have the judgment, Manoj, please have page 193. 192, para 15 minutes, where the discussion starts. And I must link it to why, as my friend says, we are constantly in a state of improving ourselves. Statutory amendments are brought in to meet the vagaries of changing times.
Yes.
And it's in that context, para 15, having heard learned counsel for the parties, it is clear that section 26A has been introduced by an amendment in 1982. A bare reading of this provision would show, firstly, that it is without prejudice to any other provision contained in this chapter, meaning thereby only chapter 4, because even those chapters demarcate responsibilities separately. This expression only means that apart from the central government's other powers contained in chapter 4, section 26A is an additional power which must be governed on its own terms. Under 26A, the central government must be satisfied, and they put it in quotes to emphasize, that any drug or cosmetic is likely to involve, 1, any risk to human beings or families, or 2, that any drug does not have the therapeutic value claimed or purported to be claimed for it, or 3, contains ingredients in such quantity for which there is no therapeutic justification. Obviously, the central government has to apply, and I underscore, its mind to any or all of these factors, which has to be based upon its satisfaction as to the existence of any or all of these factors. Then, Manoj, please note the next question, the next sentence. Power exercised under 26A must further be exercised only if it is found necessary or expedient to do so in public interest. When the power is so exercised, it may regulate, restrict or prohibit sale or distribution of so and so. Now, Manoj, please see the operative directions for a moment at para 36, at para 37. This will, Manoj, your Lordship will find at page 213.
What?
This para 37.
Here.
And I'll come back to 34 and 35. I read that on the last occasion. Insofar as drugs that have been banned, and please note, and which were manufactured pre-September 21st September 1988. That is the cutoff date. A list of 15 such drugs has been given to us by Mr. Sibbal, learned senior counsel for the respondents. We set aside, Mulats, and I have that list where I figure it serial number 7. And Mulats, which says since July 1982 and February 1986, this must be for a particular person. Mulats, that's why I'm saying the record before your Lordships only, I'm going by what is before your Lordships. We set aside the central government notifications banning them, as these cases, please note, were never meant to be referred to the Kokate committee. So incidentally, Mulats, Behti Ganga mein haath dho gaye, and I therefore find myself in that mix. The Supreme Court says you were not meant to be, but it doesn't mean that the Supreme Court says you can't be. Now, therefore, it says it will be open, however, for the central government, if it so chooses, de novo, to carry out an inquiry as to whether such drugs should be the subject matter of a notification under Section 26A of the Drugs Act. Insofar as the 17 cases handed over by Mr. Sibbal, in which DCGI approvals have allegedly been granted, we are of the view that since the Parliamentary Standing Committee itself refers to those approvals and the manner in which they were granted, we do not accede to Mr. Sibbal's that it be kept outside. So, cognizant of the fact that there was a problem with the regulatory regime, that things were shortchanged as a matter of course, the Supreme Court says one, these things have been referred to the committee, these should not have been, but please look at it. I have no difficulty with it. But I'm pausing and asking myself one question. Admittedly, Manoj, in 1995, the central authority approves the product. So please disregard 88. I am part of that 88. There is no dispute there today. The lordships are testing conduct, not in.
Then it should not help you.
I'm so sorry.
Want to be referred will not
May I
help
tell your lordships why? Perhaps it does. I was part of that list.
you. You may be part of that list, but you are in 1995 is what you've got.
No, I'm so sorry, Manoj, and that's why I said, Manoj,
I'm manufacturing, manufacturer, what do you mean by that?
I'm in the market, Manoj, and manufacture can't happen without a license.
Which is that license?
I'm sorry.
And what was the license?
It would be a license for manufacture, same.
How was it granted? Because 95 is when your name is surfacing for this combination.
Manoj, as my friend pointed out, it's a
When
very.
you say I'm pre-1988, show us what is the material you demonstrated even before the Supreme Court to claim that you are.
Look, I can place that on record. Manoj. I'll just show you lordships. That's the list of 15 that was handed over by
This
Mr.
is okay. What is the material?
Manoj, the material is, Manoj, there is a reference, Manoj, to an item number so and so in, what is AWAC?
That, Malad, they would have felt in para 38. That's where approval would have been granted and then bands would have taken place. Despite
No basis to show efficacy pre-88. That's all. Manoj, I must, like I said, Manoj, I don't want to run away from the question. The lordship is asking me to demonstrate what is the material to show efficacy pre-88. I don't have.
No, then what else is there?
Manoj, I'm so sorry, Manoj. Please consider just two
See,
things.
you gave a list to say I'm pre-1988.
Yes, Manoj.
What is the basis?
Manoj, the fact that the product was in the market pre-88.
that's all.
What is that material?
Manoj, your lordship sees what is there. Manoj, your lordship means India Manoj, the Indian pharmacopoeia, and there are each chemist has a booklet which shows Manoj products that are available in the market. Those products demonstrate, Manoj, what has been sold, various brands, Manoj, the same product with various combinations, etc.
Actually in India or was that being
India, Manoj, please note two things. Yeah, come to 56. Manoj, one, this product A is approved in other jurisdictions. That's number one. Your lordships asked me that question on the last occasion. Number one. And that is also a factor of distinction. My friend made an interesting point that it may be approved for population A, but it may not be necessarily good for population B. Nothing on the record to suggest any of this discussion, any of this.
Just a factual correction, Malad. This FTC is not approved in the countries that my friend has said. This is not approved. I've got that list.
Now, your lordships will only see, Manoj, page 56, the judgment of the Delhi High Court.
No, Mr. Rao, pre-1988.
Yes,
What is the material?
Yes, Manoj.
Apart from your name being mentioned in the list, what is the material?
Manoj, please just have two things. Manoj, like I said, Manoj, the only thing I can
It
show
was
is
demonstrated even before the Supreme Court for the observations in para 37. Otherwise, you move to 38 then.
very well. Manoj, but may I just show your lordships page 56 of the same paper book for a moment, which is the High Court's order.
Page
The fact that, if your lordship will just see, Manoj, the notification at page 55 for a moment.
Yes, please.
Yeah. This is the erstwhile notification. No, but this don't get into that. They're asking you a specific question. So, Manoj, so your lordship knows I first went through the scrutiny in 2016. The Kokate committee made recommendations. The Supreme Court says you are never meant to be sent to the Kokate committee because 21st September 1988 was the cutoff date. Now, Manoj, the fact that 21st September 1988 is the cutoff date is because, Manoj, that concept arises thereafter. Now, please just note one thing. Manoj, please have the rules straight away and please have 122E. First, Manoj, please have part 10A, 122A. That is where that magic figure of 21,988 comes from. So there is an amendment to the rules whereby the introduction of part 10A comes into play.
122A.
Yes, your lordship, just see part 10A, just above it. So part 10A, which is import or manufacture of a new drug for clinical trials or marketing. As my friend said, Manoj, the regulatory process changes. So therefore, I was subjected to an erstwhile process where the central government gave an MOC to a state licensing authority to permit licensing for certain drugs. It is not my friend's case that this combination was not permitted to be licensed in the first instance. That's not their case.
That's my case. Malad, unless there is material to show that this is approved pre-88, I can't accept that.
I'm so sorry. Then my friend should have banned me in 1988. But your lordship is right. I still have to satisfy the aspect of efficacy. And that's why I said, I'm so sorry. If I was not licensed, I would have faced prosecution under the drugs and cosmetics.
No, it doesn't mean that if you were not banned in 88, they can't do it right.
No, absolutely not. Which is why the de novo consideration. But the principle is slightly different. And that's why I said, we are proceeding on the basis that the central government must ban. That principle
So we are proceeding on your assumption that the drug is actually licensed, it's been approved for the efficacy and safety.
with respect.
But we're not able to show that.
I'm so sorry. Let me step back. And that's why I said,
Because, see, as I'm pointing out, Mr. Doctor, your thrust is, look, you cannot do this, take this strong measure of banning me because I have been in existence.
yes,
So your existence is now being in doubt.
yes,
You have existed,
Yes.
no doubt.
yes.
But what is the material? How did you come into existence? What was the test on this particular drug?
So three principles.
Till the time you have been actually exercised, the government has exercised the power 126.
That's
That's the foundation of
Yeah, answer that as a matter of law and as a matter of fact. I have my limitations, but I must answer that. As a matter of law, the fact that I had a license or somebody had a license and was in fact manufacturing this combination pre-88 is not a fact that is disputed. As a matter of fact, we'll come to whether legally it was permissible or not. We'll come to that for a moment. The fact that this product was in the market pre-21/9/88 is an admitted position. The Supreme Court notes this and carves me out. My friend doesn't raise an objection, number one. Number two, my friend treats me as a part of that list of 15 FDCs which are pre-21/9/88, which he is entitled to consider de novo as to the applicability of 26A and therefore applies 26A to me. So to that extent also, the fact that I was in the market pre-1988 is not in dispute. Now, my only answer to your lordship's question, what was the material to demonstrate efficacy? First, it's nearly 20 years, 30 years old. I'm not required to maintain it. The statutory authority having given me a license, the presumption is that I was compliant. The presumption. Actually, the parliamentary committee finds that perhaps some problems on the ground. It is not their case that my license that was granted to this combination or the approval that was granted to this combination was also procured by illegal means or whatever. No question mark specifically. But yes, the question today is this combination in today's day and age something that the central government would want in the market? And in exercise of this extraordinary power under 26A, will the central government be justified in banning the product? And the reason I'm emphasizing that word is, if your lordships will note, the original iteration of section 26A said ban. The amended iteration introduces these three stipulations, which your lordships will just permit me to go back to 26A. And please have that straight away. And your lordships will recall the submission I made as a matter of legislative intent. A statute that was in its first amended iteration, determinative of, which granted a power to ban. That statutory power is diluted and some guidance is given to suggest this. It says, first, the heading is modified, power of central government to regulate, restrict or prohibit, as opposed to just prohibit. Manufacture, etc. of drug and cosmetic public interest and cosmetics in public interest. Without prejudice to any other provision contained in this chapter, if the central government is satisfied that the use of any drug or cosmetic is likely to involve any risk to human beings or animals, or that any drug does not have the therapeutic value claimed or purported to be claimed for it, or contains ingredients and in such quantity for which there is no therapeutic justification, and that in the public interest it is necessary or expedient so to do, then that government may, by notification in the official gazette, please note, regulate, restrict, or prohibit the manufacture, sale, or distribution of such drug or cosmetic. I am here only challenging the decision of the central government to prohibit in the facts and circumstances. And I am cognizant of the limitations that I, as also your lordships, have in our inability to sit in judgment over technical data. That is something I will never call upon your lordships to do. The question is,
Ultimately, you are doing that also, that only.
no, with respect,
Because they say that they issued this notification based upon the technical data.
lordships will see that. That's why I said, Your Lordship asked me a very pointed question. What is the material to demonstrate efficacy? When I placed that material, that is not considered. In fact, in my case, in my specific case, it was given, we sought time, we had to do a study, we asked for 6 months, we were given 3 months. We submit that. The committee did not have the benefit of it, the DTAD did. That's not considered.
No, the reply says it was considered. Well, factually speaking, I'm sorry, my friend says that he sought time and he was given time. The committee did not give my friend any time.
No.
My friend has placed on record some data that he has, some trial that my friend says he has done. I don't know how and what permission my friend has got to conduct that trial. But that trial also seems to have gotten over sometime in October or August 2022. After the report has been submitted. So first and foremost, I'm really not sure how my friend conducts a trial without the permission for conducting a trial.
So you don't granted the permission for that?
No, my friend is not.
I'm so grateful.
Private trial.
Private trial, absolutely. And Your Lordship therefore asked me, what material?
And what Mr. Rao, sorry, go on.
Sorry, sir. No, my friend has to either demonstrate that a clinical trial was warranted before my product would be in the market. Not his case.
Of course, it is the case that is how my
Hear my friend, because the difficulty with dealing with a situation where I am told you are out of the market and I have virtually nothing to play with is, the fact that my friend concedes very fairly that the regulatory framework was grey. But today wants to apply something in black and white. Let him show the black and white first.
Yes, please.
So therefore, that's why I said at the end of the day, it is like saying this, Your Lordship will just test why, on what basis I am sought to be ousted. Please have that. And that's why I said, I'm not calling upon Your Lordships to sit in judgment, but Your Lordships are entitled to examine the process. Please first have the order constituting the expert committee at page 217 of the paper.
But in, Mr. Rao, is it correct in 1995?
Yes, Mr.
The regulatory regime required the efficacy to be proved?
Yes, Mr.
And somebody would have done it.
Absolutely.
Who was that entity who would have done it?
Because I must be candid, I don't know. In fact, that's some of the information that I asked for is exactly what Your Lordship is asking. It is slightly ancient data. I'm sure my friend will have that data, because otherwise he wouldn't have granted me that data.
Well, that document I've just handed over, in fact, Laborate, which is the petitioner, had submitted a representation. In that representation, I've just handed that over. In fact, it's also there in my compilation.
Yes.
But if Your Lordship will turn the first page, on the right, there's a column on top. First page, or actually the second page.
This one, approval of similar FDC.
Yes, that. Yeah. Well, show me the
Yes.
Well, on the inside of the first page.
Yes.
Details of approval. Yes, Lord. Details of approval, there's 2595 mentioned right on top.
That's 10 much. The date is wrong. It's 10 much.
Yes, 2595.
2590.
Because in fact, yes, you can see the 595.
Yes.
That's the date of the original approval that my friend has had.
Just read
placed
it.
on
What
that.
does it say? Please refer to letter 20. No objection to your marketing deal or use. Yes.
Because in fact, that date of 25 may also not be entirely, I don't know if it's accurate, because the CDSO chart says 10/3/95.
So that possibly is the letter issued to the company after 10/3/95. So that's the document that they have placed on record. I don't have the record supporting this document, but obviously it's a part of the
Is
list.
that record available? Not.
Well, we'll have to locate it. We'll have to locate it. We don't really know.
Perhaps not. And then, may I just show you?
The only thing is, Bharat, if the document, the representation that my friend has given, if your Lordship will take that, go to the next page. Well, approval of similar FDCs in the regulated markets. And if your Lordship will take the next page, your Lordship will see the approvals that my friend has placed on record. Your Lordship will bear only one thing in mind. The ban is in respect of the combination codeine, 10 mg and chlorophenamine, 4 mg serum. it is syrup. What your lordship will see, well, all the petitioners perhaps will show your lordship's approvals. They are either in the form of tablets or in the form of sustained release suspensions. Now the difference is this. When it is a syrup, my lord, it is used as an intoxicant. When it is a tablet or sustained release, it can't be used as an intoxicant. So what we have done, apart from other reasons, because ultimately, my lord, in terms of literature also, this is more of a placebo. What we have done is a syrup combination. If my friend want to manufacture it differently, they must apply and take the permission for it differently. Your lordship will see the notification. The notification says specifically syrup. And my lord, this is becoming rampantly abused all over. Codeine, my lord.
Because then they should ban codeine.
No,
Not a combination of.
codeine is not sold as a drug, sir.
I'm so sorry, Manoj, my friend should just verify that. My friend is absolutely right. If something is abused, it is codeine. This is something that is a combination of an antitussive and an antihistamine.
We are talking about a syrup.
Yes, we are.
So as a tablet, it may be approved in different. In fact, we've got this list also. Even these are not approved in the US.
Yes, my product is approved as a syrup. Oral suspension.
There you go.
No, US also. This is here.
So in the first page itself, after the index, that will also be displayed. It's only one copy. So on page one itself, in the inside page of the index. These are the ones that have been mentioned in the representation given by my laboratory. And my lord, the details that are mentioned are given here. So none of them, my lord, the one that is a syrup is item 6. But that is not in the combination that your lordships are looking at.
It's in a tablet form.
My lord, item 6 is a syrup. Codeine phosphate versus promethazine and hydrochloride. That is not the combination that your lordships are looking at. That's a different one. That's a different combination. And the others are suspension, extended release, etc., etc.
In fact, my friend makes my life a lot easier. A slight tweak to a combination can alter its efficacy.
Absolutely.
And therefore, your lordships will have to be shown that each of these products has been tested with reference to these specific combinations. And therefore, Manoj, I'm asking myself, and that's the point I was making. A regulator who says, I will not allow you to sell this combination because it is harmful, he has to tell me that this combination is harmful.
No. You have to take permission from the regulator saying that this by
I'm grateful. Your lordship is right.
all documents and research material, drug
Please.
trial, whatever.
You're absolutely right.
Effectively,
Please see what is approved. Manoj, your lordship will just test that the same company.
if petitioners want me to conduct a trial and show that
No, I'm so sorry. That's not even what I'm calling my friend to do. I'm so sorry. I'm asking my friend to do his job, but I'll show your lordships what the job is. It is not for him to conduct a trial. Please permit me, Manoj, just to show your lordships what was approved. Please have their document, not mine, page 84 of my additional documents, Annexure P16. And look, this may perhaps also address a question that your lordship put with regard to material, because your lordship has that? Page number 84 if your lordship has. This is Annexure P16. And the heading says it all.
Please wait. Yes.
But Annexure P16 is a list of fixed dose combinations approved by the Drug Controller General of India since 1961 to 31st December 2019. So, Milas, the fact that the pharmaceutical industry has combined different products of varying strengths is something that is not unknown to science or to the drug controller. Now, please note, your lordship sees the first approval is January 61. Now, there are two ways of verifying that this approval is kosher. One, that there is an approval. Number two, that my friend says that approval was given in accordance with a fixed study. But that does not mean that my friend cannot ask for a revised study 10 years down the line, 20 years down the line. Antibiotics, for instance, because your lordship knows, now resistance. So therefore, we find ways to try and limit use, etc., etc. Those are all regulatory powers. I figure in that list, at page 175, at serial number 1217. And I'm not approved as a tablet. It's a syrup.
Serial number?
1217. And please contrast it with 1216 and 1218. And also, please see, so 1216 is an uncoated dispersible tablet. 1217, that is me, each 5 ml contains chlorpheniramine maleate at 4 mg, codeine phosphate at 10 mg, for dry cough. The date of approval, which is the last column, is 10th of March 1995. Now, I ask myself today, in 2023, can I be called upon to say, explain the basis on which this approval was granted in the first instance as a matter of law? I'll take that the presumption is all official acts have been done properly. This has never been challenged. And on the contrary, we have all been given licenses to manufacture and sell pursuant to this approval and prior to that also. But I must satisfy your lordship's conscience that when I'm calling upon your lordships to interfere with a ban, I am not calling upon your lordships to say they can't regulate. The Drugs and Cosmetics Act is the power to regulate. That is the reasonable restriction upon me under Article 19. The rules, which confer delegated authority, please have section 33. This is an interesting place. Please just see the manner in which the legislature carves out certain responsibilities for a minute. Section 33 of the Drugs and Cosmetics Act. The central government may, after consultation with or on the recommendation of, so it doesn't necessarily have to be a unilateral act, it could come from the authority which is more in tune with what's happening on the ground. The board, which is constituted under section 5, and after previous publication by notification in the official gazette, make rules for the purposes of giving effect to the provisions of this chapter, provided that the consultation with the board may be dispensed with if the central government is of the opinion that circumstances have arisen which render it necessary to make rules without such consultation. But in such a case, the board shall be consulted within 6 months of the making of the rules, and the central government shall take into consideration any suggestions which the board may make in relation to the amendment of the said rules. Now, please note, after the regulatory powers minutes, this is not one of those rules that is placed before Parliament. Please see that. This is purely administrative, delegated legislation. Now, the reason the legislature in its wisdom confers this power is because there are multiple authorities who are expected to exercise their individual checks and balance roles in the framework. Now, unfortunately, what I will demonstrate from the record, and which is why what is conspicuous by its absence in this case is the record, that each of these authorities has failed your lordship and the statute, and as a consequence has impinged my rights and has gone beyond what was reasonable as a matter of law, and therefore the aspect of proportionality which your lordships repeatedly emphasize when testing conduct of authorities comes into play. And that's why I said, not for a minute am I suggesting that I cannot be regulated. I cannot survive if I'm not regulated. But is the answer a ban? And is a ban justified in the facts of this case in light of what has fallen in the legislative, the legal history, the litigative history of this one case, and of course, the view that your lordships have taken in other matters. But stepping away, as a jurisdiction, do we want to send a message that my response to something that I don't like . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
Do you have 1995 record with you?
Well, I've already asked for that. They are going to look for it. I follow. I follow. One aspect, Lord, if your lordship will take for a moment, the representations that had been received by
Because
us.
we want to know on what basis this letter was issued.
I agree.
This 2-5 to 1995.
In fact, my lord, the entire genesis, when your lordship will notice the first few paragraphs in Pfizer, the entire genesis was the fact that these approvals seem to have been given, a lot of these approvals seem to have been given in ways that were not exactly.
So we would like to know whether proper study was done, whether research was done,
I follow.
or the approvals were given mechanically.
I follow. Your lordships are right about that.
Because if the government was at fault in 1995, then it's a different issue altogether.
That's right.
Because they are concerned with the public safety, the
Yes.
health issue. So if how was these licenses in 1995?
And your lordships are right. As an officer of your lordship's court, I must say so, that if we have been amiss there,
That's right.
then we should also be hauled up for that. Some, your lordship's observations may not be entirely inappropriate. So I agree with your lordships there. But that perhaps would be even.
Take for you to trace this.
I'm sorry,
How much time will it take for you to trace the report?
Well, your lordship will list it after the break. I will locate it. I can locate what I can. But your lordships are right. That would be important.
So we'll continue with this case at 2:15.
Oh, I'm sorry.
How much time you need?
2 weeks, 2 weeks.
Okay.
I meant the hall. Sorry. Just one aspect, Lord. Your lordship will take in the compilation, in the documents that I've given, the representation by Shreya Life Sciences in the pen drive.
Pen drive, they will not be able to.
Very well. So your lordship will take this form.
It's on the, it's on the.
अच्छा that they said no, that they said deal exam.
So that is.
Your lordship will see that. वही दे दो. Well, now, in terms of the information sought,
Yes.
we are asked specifically for the safety and efficacy data. Your lordship will see the first line there. Right there on safety and efficacy data. They say very clearly and honestly that there is no published study on the safety and efficacy of this FDC. Very clearly.
This is the form.
This is a representation submitted by one of the manufacturers. One of the petitioners.
That is.
Your lordship will see that line there, right? No,
That's okay. Please take that against me. And just to assist, my friend very fairly hands over a document. In the United States, the FDA approves the same combination with a higher strong dosage. Well, it's with a prescription. That's all. That's the
syrup
point I mean.
form or in a tablet form?
Well, this is a syrup. Oral syrup. That's the point.
That's been discontinued. That's the reason why the annexed letter.
Marketing status is not discontinued. Prescription. This is prescription. The other ones have been discontinued. That's the point.
That's what I was saying. Look, this is not the combination.
No, it is the
It's
combination.
not the combination. It's promethazine.
It's not the combination involved in your case. This is what he's saying.
Sure, Your Lordship. That my combination is approved in the US and it works. But anyway, that cannot be the ground on the basis of which I want to sell in India. Because we are in the business of make in India today.
Shri Rajeshwar Rao, learned senior counsel for the petitioner. Shri Kirtiman Singh, learned ASG for the respondents. Learned counsel for the central government has brought to the notice of this court letter dated 2/5/1995, by which permission was granted for the fixed dose combination by Government of India. Point. This court would like to know on what basis the aforesaid permission was granted and what was the materials submitted by the manufacturer to the Government of India / competent authority. Shri Kirtiman Singh prays for 2 weeks' time in the matter. He is granted 2 weeks' time. List the matter after 2 weeks.
10th November. 10th November.
Your Lordship said directed my friend to file the relevant record. He has filed 4 volumes. I take it that is the relevant record.
Pen drive is a security risk, so they will not be able to take the pen drive.
We have not,
Because if we can't trust the government, then who can?
Can it be emailed to the court first?
we have not been given this pen drive. So copies to us.
Mr. Ketuman Singh prays for permission to file certain documents. He is permitted to do so with a copy to the other side.
I'm grateful.
But that's the record that the lodge want to make on record. The record.
That's right.
That's right.
Yes, please, next, please.
Most grateful.
The witness, and tomorrow is my last and final opportunity for responded evidence. On 1st of August, my application under 1310 was dismissed. Your Lordship, for the first application which was dismissed, again, I had to come to your Lordships, and your Lordships